one, learn to resist the siren call of flattery. Because if you don't, you'll end up standing here where I am. Mark chose the title. He badgered me over a period of a couple of weeks. Can you hear me back there? He badgered me over a period of a couple of weeks to come up with a title. And he had told me that he wanted the subject matter to generally follow the lines of the little talk I would have with the misdemeanor lawyers when he requested me to do so. And I was too busy trying to figure a way how to get out of this to think of a title. So Mark chose the role of a prosecutor. When all's said and done today, why, probably a more adequate and descriptive title would be Rambling Jack's Farewell. I've noticed lately people come into the office and I start talking, and I don't stop talking till their eyes glaze over. And I figure it's about time to leave. So anyhow, some of this material is going to be very familiar to some of you. And I make no apologies for that, because learning is a repetitive process. And the more you hear something, the more you do something, the more apt it is to stick. The things that I say, many were learned from making mistakes. Sometimes the most emphatic learning experience you can have is when you do the wrong thing. The goal is to try to never let it happen again. So I would like to be able to live up to everything I say, and I hope that we all strive for that. But certainly, if I give you any rules or suggestions, you can rest assured that I've broken probably 60% of them myself. We have important jobs. And that has been emphasized to me not only just through my experience over the years, but I've had the distinct honor and pleasure of sitting on the interview committee for most of the interviews over the past several years. And it's really been interesting to hear these highly qualified, articulate, talented young people standing in line to get a crack at a job at our office. And they recognize, to hear them put it in the words of this generation, why they want to be prosecutors makes you proud to be one. It's a heavy responsibility. Never forget that. This job is a heavy responsibility. You must be responsible to the community, to the elected DA, George Kennedy, to yourselves, and to each other. You've all heard at the end of a trial when the defense is making an argument and maybe they're looking for something to say, some filler material, and they talk about the awesome power of the state. And they'll maybe say it again, the awesome power of the state. Against this poor defendant. You're sitting there, having suffered through a trial where half your witnesses didn't show up. Half of those that did said something different than you thought they were going to say. The tapes were unintelligible. Part of the evidence was lost. And God forbid, maybe even the lab screwed up. So despite what we may think of this awesome power of the state argument by the defense, the Supreme Court of the state of California sees it in the same light as the defense attorney does. In Ray Ferguson, a 1971 case, I believe that was a discovery case, the court said in part, the duty of the district attorney is not merely that of an advocate. His duty is not to obtain convictions. but to fully and fairly present to the court the evidence material to the charge upon which the defendant stands trial. In light of the great resources at the command of the district attorney, there we have it, great resources at the command of the district attorney, and our commitment that justice be done to the individual, restraints are placed on him to assure that the power committed to his care is used to further the administration of justice in our courts, and not to subvert our procedures in criminal trials designed to ascertain the truth. Now, this awesome power really comes from our ability to charge people with crimes, which results in their arrest and frequently incarceration. Once you get to trial, the playing field is leveled. So it's in the charging where we must be very, very careful in exercising our discretion. Unless consciously checked, one through constant repetition of reviewing cases, and sometimes if you allow yourself to get sort of a mentality, a stockade mentality, you can develop an issuing philosophy that is best exemplified by the logo on a T-shirt that you frequently see sold at gun shows. And that T-shirt shows a skull, bleached skull with a dagger to it, and maybe the skull's wearing a beret or something. The logo says, "Kill them all, let God sort them out." And what we do not want to do is develop a philosophy of charge them all, let the jury sort them out. For the dedicated criminal, the gangster, whatnot, arrest, incarceration, in the process is just part of the cost of doing business. But for other people, this experience may be humiliating, brutal, and nerve-shattering, and affect them forever. For your guidance, I strongly suggest that each of you obtain a copy of the following, and tape it to your desk, hang it on the wall, or put it in your trial book. This is a memorandum dated October 1st, 1997, to the criminal staff from George Kennedy. Thank you for promoting the following well-known foundations of our fine office. Cases should be analyzed on evidence and triability, not personalities, friendships, or politics unrelated to the likelihood of prevailing before a jury. Statutes should be construed to effect their reasonable purposes. We believe in doing the most good for the most people. A four-pronged test is utilized in deciding to authorize criminal charges. 1, was there a crime? 2, do we know who did it? 3, can we prove the case beyond a reasonable doubt at a jury trial? As a resource allocation mechanism, we should have an 80% likelihood of prevailing in cases where future public safety is not at stake. A lesser likelihood is appropriate for especially serious crimes, persons who pose a danger, or to end a dispute which would continue to fester. Experienced trial attorneys should be able to assess this likelihood with accuracy. In all cases, we must be sure a person is guilty before charging. 4, is charging the right thing to do? If the first 3 charging hurdles are surmounted, this 4th prong test should be used sparingly, with great weight put on uniformity. Supervisors should be consulted if applicable standards and authorization have not been set. Say, this is worthy of being placed in the future. Many a time when you have a troublesome problem, the handling of the case, the issuing of the case, go back and ponder these words. They succinctly state what it's all about. Integrity. This is your shield and your sword. Your integrity, and it's more actually your reputation for integrity, is virtually everything. If you remember in the Burt Lancaster in the movie where he played the evangelist, Elmer Gantry had a little thing that he went into where he would say, "Love is the morning and the evening star." Well, in our case, integrity is the morning and the evening star. It is your most valuable asset. It must be earned, or the reputation for integrity must be earned. I don't think that you walk into a courtroom and you are automatically assumed to operate with integrity. I think the moment you walk in, or the moment you begin negotiations with somebody, you're on trial. But if you persevere, live by the rules, make your word your bond, it'll be the most valuable thing that you have in the practice of law. And once lost, it's almost impossible to reclaim. And in this area of integrity, the vilest swamp, the pitfalls of many, what can really be your Waterloo is discovered. Reasonable people can differ, but my advice to you is err on the side of openness. I don't think you can go wrong that way. The next important attribute that we need to be aware of and work on and utilize, another tool, are your instincts. That's that little gnawing feeling you get right here sometimes when you just made a decision and then you're second guessing yourself, or maybe you're in the decision-making process and there's a voice that you hear out here that tells you something that doesn't maybe quite square with the literal facts that you're aware of. In fact, sometimes it's at war with your intellect. But these instincts are a marvelous thing. You need to hone them, to sharpen them. Then you need to test them. And once you've done that, once you've developed them, then trust them. This could be your greatest tool in a time of crisis, be it in the courtroom or in your personal life. We do have tendencies, which I don't know whether they're called instincts or not, which sometimes we have to learn to curb. For example, the instinct to flee at a time of danger. At times we must curb that and learn to stand up, stand fast. But work on that. And what you do is, a situation comes up and you get that little voice, that gnawing feeling, make a note of it. Make the best decision you can, and then later, when the results are in, go back and check it against your instinct. You do that enough, work at it hard enough, you will develop good instincts for courtroom situations, life situations, everything else. A first cousin, or maybe even a parent, or a child, I should say, of instinct is judgment. And like all human attributes, some people are blessed with good judgment. They seem to be born with it. They became known for it. And it's a fine thing to have. Some people are cursed with bad judgment. But most people fall in between. And you can learn and foster good judgment. And I think maybe the simplest way to do that is find somebody, maybe more than somebody, maybe 2, 3 people, whose judgment is widely respected within your community. Whether your community is your group, your team, your office, or within the whole judicial community. Seek their advice and test your conclusions against theirs. And if they differ, find out why. Why is your conclusion or your tentative conclusion different from this person who has the reputed good judgment? Everyone makes a mistake. No one's right all the time. If you go through this exercise, I believe it will assist you in developing good judgment. Once you have confidence in your judgment, occasionally you need to go back for a tune-up. We tend to drift a little bit. And make the analogy to rowing a boat. I haven't rowed a boat for a long time. It's my recollection that you are looking backwards and you're headed this direction, and you're rowing this way, and you sort of fix on an object behind you rather than in front of you to maintain a course. But unless you're an expert sailor, why, it's my belief, from my experience, that you tend to drift a little bit this way, then you correct and you come back on course, then you drift a little bit this way, and so on and so forth across the lake. I think in the practice of law and doing the thing that we do here, in issuing, trying cases and whatnot, I think we need to check our course periodically. And that frequently might be a better word, because you'd be surprised if you really sit down and take a look at what your goal is and look back where you've been. You may need to make a change. And I think where I notice this the most is when Dave Davies and I are issuing cases. And Randy Hay and Don Scher have helped us by events. Will have a subliminal effect on you, like if we get a series of verdicts that we're not particularly happy with, why you need to go back and look at your charging, look at analysis of the case, etc. Sometimes you'll get these great, almost unwarranted verdicts, and that'll cause you to maybe not look for enough at charging time. You'll be cocky, confident. You have to keep on course. Be prepared to change with the times. When I was fairly new in the office, which would be a lot of years ago, maybe 34 or so years ago, why, I remember a case I tried that involved possession of one marijuana cigarette. This was a felony in those days. The individual on trial had a prior conviction for possession of marijuana. There was an issue that was a tribal issue in the case, and we went to trial. The individual was convicted, and he was sentenced to 7 years in state prison. By the same token, in that period of time, drunk drivers, even if people were, there was some injury sometimes, drunk drivers, usually a $300 fine. Almost never jail, nor other disabilities. Their single biggest worry was that their insurance rates would go up. Look at today. Contrast that with today. Today, possession of that marijuana cigarette gets you diversion, I believe, while a fairly serious drunk driving incident with priors can send you to prison. So times change. Be prepared to change with the time. Don't rush off for some fad or some passing fancy. Don't listen to the false prophets, but be alert. Change with the times. Attitude, tremendously important in doing a good job. We are public servants. Never, never forget this. This job was not created to make you happy, your family secure, or your mother proud of job is doing something for the people of the state of California. Whether you like it or not. It's that simple. We are public servants. All those people out there, which would include the person ranting on the street corner, the person driving the bus, we work for them. They don't work for us. The most common complaint of citizens about the people that I have supervised over these years is they don't return their phone calls. And you can't imagine how important that is. A person should make 100% effort to return every phone call. It festers with people, and it drives them crazy, and they can come in and they could have had wonderful service by our lawyer in the prosecution of their case if they're a victim or if they're a witness, except if the lawyer doesn't return the phone calls, all the rest of it goes out the window. Learn to listen on these phone calls. Learn to take some abuse. You may be defusing a very volatile person who is on the brink of doing something violent or dangerous to someone else. And your willingness to let them vent for 15 minutes, 20 minutes, 30 minutes, you might save a life. That's maybe a little far-fetched, but I firmly believe that it's a very important aspect of our job. However, if you're talking to a rational person and they want to abuse you, there comes a point where enough is enough. And at that point, why, you have rights to expect courteous conduct, and you can lower the boom when you reach that point. Seek the challenge. Volunteer for the tough case. Through adversity comes strength. And the time, of course, to commence this is when you're there in misdemeanor land and the cases are being handed out. Seek the tough one. That's where, when you're pressed, that's where you're going to learn. When you're forced to reach deep into your meager bag of knowledge and maybe become innovative and have to go around and ask for some help, that's where you learn it. When possible, seek out the case. Maybe it isn't the toughest case, but maybe the toughest defense lawyer in town is on the other side. And that's where you can get a real education. You may win 15, 20 cases in a row and get to thinking you're pretty sharp. But you come up against a John Williams or a Tom Nolan or someone like the late Brian Scheckmeister, man, you can get undressed pretty fast. And so go back, look for those tough cases. Yeah, it's going to be hard. But I grant you, it'll make you a better lawyer. Be a team player. We are a team. That's simple. Volunteer for things like calendars. Volunteer to help out your buddies on your team if they're having a problem or something. It makes for good morale. It makes for better friendship. It makes for a better office. I say, as a supervisor, give me a team player over a prima donna any day of the week. In fact, give me one team player over two prima donnas. And you'll be better off. Learn to take orders. We're lawyers, and we like to think of ourselves as being extremely independent. We earned that right by the years spent in law school and passing the bar exam. But when you're working in an organization this size, there has to be some rules that govern the way we do business so that there's uniformity and the job is done right. So unless an order compels you to do something that's morally wrong, why, be prepared to follow it. Don't be a problem. In the days of Louis Bergner, I spent some time in his office because I had my own ideas on how to do things, and so I learned this the hard way. Perspective. You are not police officers. You're not cops. You're not trained to be cops. The cops don't think you're cops, so why should you? Just right here, I heard this subject addressed. It was very nicely done. Randy Hay stood right here last Wednesday, and he gave a talk to the homicide investigators of Santa Clara County. And his text was the Dave Davies on-call homicide deputy. And of course, as you know, Randy does 80% of that, and Peter Wade is his backup. And Randy really emphasized and pointed out that even when he's out there on the scene, he's not there to run the case, to tell the officers how to do their job. He's there to be helpful in an advisory capacity. This doesn't mean that you can't experience the thrill of participating in an involved and successful pre-filing investigation. Just remember what your role is. Keep things in perspective. Treat people right. We all fail at this. But we should never give up. We should always keep trying. The old golden rule. Doing to others as you have others doing to you. A person ought to repeat that every morning of every day of their life. It would sure make life easier for all of us, and keep yourself from doing things that you may regret the rest of your life. Be pleasant and courteous to victims. We know that. That's our job, okay? We have to give these victims TLC and make them feel like this office cares, because we do care. But don't let it stop there. Witnesses can be a pain. But as long as you can, you treat the witness as you'd like to be treated yourself if you were in his or her shoes. Police officers. I'm continually surprised when I hear reports of some of our deputies abusing police officers. They can be a pain when they don't show up in court, or they don't read their report. When you ask them the first question, officer, what's your name? Oh, well, yeah, I put my report here. Yeah, but you know, they're just people trying to do their job, and treat them right. But maybe most important are the little people. Maybe that's politically incorrect. By the little people, I'm talking about our support staff. We got some great people doing really tremendous work for us. If you look back over the years, people like Renee and Lupe who've gone on to other jobs, boy, those people were about the third vertebrae and the backbone of the office. People who take out your garbage, treat them right. Treat them right. Sometimes treating people right means that you have to be firm with them. You sometimes have to discipline them if you're in that position. There are times when you have to do hard things. But as long as you're doing it for the right reason, why, that's what's important. Talking about a tune-up, so to speak, I was assigned to the Los Gatos court many years ago with the late John Horning. those of you who knew John, well, you don't need any explanation. For those of you who never heard of him, John Horning was an early public defender, and he was a very easygoing guy who tried to find some humor in the grim business of being a public defender. And he would occasionally do things that I'm sure that drove his supervisors wild, but he went home with a sense of enjoyment. And he said that his clients all called him the dump truck, and he could laugh about it. But John was a much better lawyer than a lot of people gave him credit for. So we were out there in Los Gatos doing mainly prelims. Ed Taylor was the judge, and then we roared through a lot of cases, and we hit shut pretty early because I put on, in those days we prided ourselves in putting on the bare bones prelim, and John would just ask enough questions to assure himself that he was doing his job, and when his bosses looked at the transcript, well, they couldn't criticize him too much because he knew how to hit the important spots. So this went on for quite a little while, and what I didn't realize is I was getting sloppier and sloppier. Just through inattention and repetition. One day I go to put on a fairly simple prelim, and the first question out of my mouth was objection. And it went that way all afternoon. John Horning tied me in knots because I had, in 2 or 3 months, forgotten most of the evidence code. I wasn't using it. And afterwards, I got sort of mad. And afterwards I said, God damn it, John, what the hell are you trying to do? And he told me, he said, Jack, he said, I'm doing you a favor. He said, you're due to go back to felonies pretty soon. He said, you can't go back up there the way you are. So I said, I'll just give you a tune-up. Let us not forget the defendants and their families. Not all criminal defendants are evil people. Some of them might even be your relatives. There are people who, through addiction to drugs or alcohol or easy living, get themselves into a cycle that they seem to be unable to break. And they're really, like I say, not bad people. And so treat them with courtesy and respect, and treat their family with courtesy and respect. And I'm going to read to you a letter that I think really demonstrates how a person lived up to this credo. And it's dated November 11th, 1997. It's to Mr. Cameron Bowman, Office of the District Attorney, 70 Heading Street, San Jose, California. Ray Alberto Guillen. Dear Mr. Bowman, Alberto and I would like to extend our gratitude and thanks in allowing our family to be present in the courtroom during the trial. We appreciated the fact that you trusted us enough to allow us to be there during Alberto's time of need. Also, I personally would like to thank you for the courtesy you extended to Alberto. During my visits with Alberto, he mentioned the kind treatment he received from you, knowing how difficult a case this was. Again, I thank you. Sincerely, Angelica Guillen. Now, this is the kind of letter everyone would be proud to have in their file. Talking about letters, these letters that I guess we call them attaboy or attagirl letters. There's been a practice that has existed probably ever since trials, pens, and writing paper were invented. And that is the solicitation of these attaboy letters from police officers, victims, and witnesses. And I don't think that's good practice. Your supervisor soon sees a pattern, becomes aware of that. You're not fooling anybody. So that's just a little thing I throw out for you. Okay, trials. Obviously, this is not a lecture on how to try a case. We've had some excellent lectures in the past on that subject, but I want to make just a few observations. Style. Be true to thyself. Your raw material is determined genetically. But through education and experience, you can grow. You can become more versatile. You can pick up skills if you only have a moderate amount of natural ability. But there's still that core that's you. And, for example, I can't see Dolores Carr going in and presenting herself as George Kennedy would. There are different people with different skills, different ways of presenting things. And when you're there in misdemeanor land is the time to cautiously experiment with style. If it doesn't feel right, and if the jury gives you that, go on to something else. But that's the time. And you'll find it as you go along. If you try to integrate a little something here and there, you'll soon find out what works for you. And there's a lot of ways of presenting cases as far as style goes. Watching other people can give you ideas, but be careful. You can never totally imitate someone else. And frankly, most jurors can spot a phony unless there's a defendant on the witness stand. Evidence. Cases are won by proper presentation of evidence. Cases are lost by poor presentation of evidence. Cases are lost by forgetting to put in relevant evidence. Cases are lost by the underutilization of evidence. Cases are lost by the misanalysis of evidence. Cases are lost by poorly arguing the evidence once it's all in. Know the evidence code. This is a George Kennedy precept. And so do your very best to learn as much of it and learn how to use it. Just knowing it isn't really, and being able to ramble off. You have to know when to apply it and how. But work at that. That's another powerful tool. As our famous deported Ulysses Beasley said, and he always usually said that his daddy told him this, he says, what you don't know is a sword in the hands of your adversary. Another thing about trials is court trials. Don't forget, as you move through the ranks and get into more serious cases, that sometimes a court trial is really a powerful tool. Jury trials are more glamorous. We assume that it takes greater skill to convince 12 people of something than one person, which is probably correct. However, at the right time, by picking the right judge, is a heck of a lot easier than picking the right 12 jurors. So don't look down your nose at the court trial as a means of presenting and winning your case. Well, I call this next segment the long haul. This deals with how to survive 30 years of trying cases. I think perhaps in a lecture that was given by Tom Hanford 2 or 3 years ago, maybe it's 5, time passes in my way. Tom emphasized that you can't take the burden for what the jury does. Now, if you make a mistake, that's one thing. If you, like I say, don't present your evidence properly, yeah, you should be upset with yourself and you should take steps to amend that. But you get those verdicts sometime where you know you did everything right. No one can tell you. You go around asking people, the judge, the bailiff, the jurors, and no one has any criticism. They just saw it differently than you did. We're human. You're going to agonize over that, but somehow you have to work at to do your grieving and then get over it. Learn from it if there's something to be learned. But don't just let it eat your heart out for days and weeks. You got 100 more cases to try in the next few years. So don't leave a piece of yourself in every courtroom that you occupy for a few weeks or a few months, or in some cases it just run over a few years. If you do, you'll be burnt out before you're 50. And you know what? You don't have any nice pastures for burnout lawyers around here. You guys signed up to be trial lawyers, and there's no guarantee that you're going to be a supervisor or an assistant and do that type of work. You might be trying cases at 55. So you've got to pace yourself. Some of the things you can do to help pace yourself is work out, exercise. It's probably one of the most important stress relievers that known to man, or woman, or beast, for that matter. A healthy body and a healthy mind. Even in the midst of a heavy-duty long-term trial, find a way to get some exercise. Get some of that, shed some of that stress so that you're sharp the next day. Develop hobbies. It's dangerous, very dangerous if you let this become your entire life, at the expense of your family and yourself. Find something that you can do aside or plus the exercise that you can lose yourself in. You can go home and just like you step through the door of a room and you leave all your office cares behind and just immerse yourself in something. And this can be, the possibilities are endless. Reading, of course, I think for a lawyer is an absolute must. You can do it for relaxation. You do it to keep up with the changing times, changing jurors' perspectives. You can be ever alert for sources for argument, use an argument. And while we're talking about reading, I think every person should read the daily journal. It took me a long time to learn that. I sort of relied on the Cal DA's case analysis, which of course always runs a month or two behind. And you could be over in court, and lo and behold, the public defender comes up with this new case. And it blows you away, and the judge doesn't know about it, and you're sort of wondering if this is bona fide or not, and they whip out their copy of the daily journal and read the case to you. It's sort of embarrassing. And it takes so little time during the day to give it a once-over. And there's interesting stuff in it, too. What's the latest episode in the saga of Terry Hallinan? Up on the goings on in San Francisco. Or Los Angeles. They have some good times down there, too. You can read. I try to read it while I'm eating lunch. That way I'm working. Okay. Lying. Lying will get you in a lot of trouble. You can commit, in this business, a lot of sins. You can do some pretty wrong things. But if you if you don't lie about it, you have a chance of surviving. But if you want to ensure that you get run up a rope for some act that you've done, is to lie about it and try to cover it up. There's just something that drives people in charge crazy when their employees lie to them. Some, last year maybe, the West magazine, it comes in the San Jose Mercury, did a little story on the two cops who were somehow involved in this house of prostitution down on the Alameda, as I recollect. And they were, taking bribes or services, or they were involved somehow. And they got caught, and I don't believe we prosecuted them. I don't think the evidence was there, as I remember. But so their story was played out in the the review board and civil service board hearings and whatnot. One guy admitted to a lot worse conduct, while the other tried to lie his way out of it. Guess who's still working as a police officer? The one who didn't lie. So lying's just really, really bad stuff. I can think of almost no instance where it's going to end up doing any good. Be careful what you wish for, you may get it. I think a lot of people here wish to be team leaders, wish to be wives, wish to someday be assistants. I suppose in some cases money is the driving factor. In other cases it may be power, it may be prestige. But let me tell you, it gets lonely at the top. And the higher you go, it's like a pyramid, the lonelier you get. And you have to do hard things. Things that are no fun. They don't make you feel good, but you know they're the right thing to do. And you're the instrumentality to see that these things happen. You have to be judgmental. You can't sit back and wait for things to play out. You have to take action. Sometimes you're not dead center. So what you should do if you ever get in that position is, yes, make those decisions when they have to be made, but leave the door open. Leave the door open. You'd be surprised how many times new knowledge or something will come to light, and if you leave the door partially open, you can set things right. Supervising is really getting the most out of people. And people are sort of like different kinds of automobiles. You have race cars. They need to be tinkered with a lot. They need a lot of TLC. There are the Cadillacs, the people with the natural ability that just take this business like a duck to water. There are your rugged, the pickup trucks, people that you can count on to carry the heavy load day after day after day. There's even a use for the jalopy, the old beat-out car, and your job as a supervisor, if you get in that position, is learn how to identify what kind of car this person is and what kind of use they're best suited for. You can save a lot of people's careers if you become adept and adroit at doing that. Well, we're getting pretty close to the witching hour, and I have one final word. And this is a quotation from a letter written by Paul Brest, the dean of Stanford Law School at the time he wrote a letter. And I quote from Dean Brest: "There is an old Chinese saying, quote, 'Let your skills not exceed your virtue.'" And Dean Brest goes on to say, "A skilled lawyer without a commitment to justice and the ethical practice of law is not an asset, but a menace to society."